Good morning, good afternoon and good evening to our waste crime presentation today. On behalf of the Asian Development Bank Train the Teachers Environmental Law Program and the supporters of today's webinar, the United Nations Environment Program, the Asian Environmental Compliance and Enforcement Network and the Asian Research Institute for Environmental Law, my name is Matthew Baird and I'm happy to welcome you here today for this exciting event. Looking at a waste case study. Last month, we had two exceptional presenters, Dr. Amanda Cabrejo-Larue from the Regional Office for Asia and the Pacific of the United Nations Environment Program, who gave an overarching view on environmental crime. And that was followed by Nancy Issarin, a consultant with Ambientura, who focused on waste crime and some of the issues surrounding waste crime. Both of those presentations are up on our Teach Environmental Law Asia website, and we'll provide you with that URL shortly. Today, we then go into a more of a deep dive with our special guests, and I will shortly introduce Amanda Cabrejo-Larue to introduce Howard McCann. But first, can I also ask everyone to please fill out the attendance form to ensure that we can provide you with a certificate of attendance. And also for the question and answer section of this presentation, we have the chat box and we also have the capacity using the reaction button to raise your hand when you want to ask a question at the end of the presentations. So without further ado, I would like, with great pleasure, to introduce our former speaker from last month, Amanda. And Amanda will introduce Howard. If I can first of all just introduce Amanda, she is an international legal professional specializing in environmental law, criminal justice, and human rights. She is currently supporting the United Nations Environment Program Regional Office for Asia and the Pacific as an environmental law expert. In this role, she is contributing to the development and implementation of projects in the area of environmental law and governance, including on environmental crimes, with a focus on waste trafficking and wildlife crime. It's a great pleasure to welcome you here this evening, Amanda. Thank you very much.
Well, thank you, Matthew, for the introduction and organizing this new session, this new webinar, and this very fascinating series of webinar. And it's a great privilege for me to be moderating the session today and to be here representing the UN Environment Program and especially the Office for Asia and the Pacific. So today we're going to have with us Howard McCann, and please don't hesitate to turn on your video already. Howard is a senior lawyer at the Environment Agency in England. He's a barrister by profession and a member of the European Network of Prosecutors for the Environment. So Howard has spent 19 years at the agency prosecuting and advising on of waste, water pollution, producer responsibility, and waste exports. He's also very experienced with providing trainings on waste and other matters with the EU Impel Network, the United Nations University, UNEP, and more recently, the Basel Secretariat in Rwanda. So thank you very much for taking the time to join us, and we very much look forward to hear about a recent case, a successful case you've been leading. So the floor is yours for 30 minutes, and after that we're going to have another 30-35 minutes for questions, for Q&A, and we hope to have a very good discussion, because we know there are a lot of people from different enforcement agencies here in the webinar today from all across Asia. So please don't hesitate. Okay, so the floor is yours, Howard. Thank you.
Amanda, thank you very much for that very kind introduction. And Matthew, thank you very much for the invitation to chat to everybody today. I hope this will be informative. It was a very big case for us. and continues to be an important area of law that we regulate and regularly prosecute in. You may see that I'm wearing a poppy today. Today is the 11th of November. It is Remembrance Day today here. And we wear the poppy to remember all of those people who have been impacted by wars from the First World War right up to the present day. And so it's a very reflective day for us today. And on Sunday, we have what's called Remembrance Day services around the country that will celebrate and remember those that have been affected by war around the world. And so I just thought I might just open with that if there was any curiosity as to why I was wearing the red poppy. So just moving on to the illegal exports case study today, and Angelo very kindly is going to direct the slides for me. As mentioned, I am Howard McCann. I'm a senior lawyer at the Environment Agency. As Amanda has said, I'm a barrister by profession like Matthew, and I focus on environmental prosecutions. That is my sole area of responsibility in the UK. We have a state prosecutor that will deal with the mainstream criminal offences such as terrorism, aggravated burglary, murder, and all of that sort of nasty stuff. Not to say that environmental law is not nasty, because it is, and that's why we are here today. It affects all of us and it impacts all over the globe. And so next slide, please, Angelo. Right, just a recap of where we are in the UK in terms of waste export. And this law has been developed over a number of cases from about 2010 onwards. We've been to the Court of Appeal on a number of occasions on points of law relevant to this area of law. And this is where we are today. So from our perspective, once you have established that the material is waste, and that is obviously the major hurdle in most of our prosecutions, sometimes it's quite obvious, like it was in this case, but in other cases it may be more difficult and more onerous to prove. So where waste is exported that exporters might say is second-hand used materials, such as electrical items, that is where it's more difficult in circumstances to prove that it is in fact waste, but that is our job. And then, so a shipment of waste will start at the point of loading. So if it is loaded in the middle of our country, somewhere like Cambridge or Oxford or Liverpool or Manchester, it then starts at that point and continues until its point of recovery in the destination country. So it is a continuing action of export. Anybody can be involved in that export. That's what our law has said. So from the point of loading, the site at which the waste is produced, the driver of the truck that conveys the waste in the 40-foot container from the load site to the port, the shipping line that then loads the container of waste onto its ship and then exports it to the recipient country. It is then a matter for us as the prosecutor to decide who to prosecute, because clearly it is not in the public interest for us to pursue the driver of the truck, because he was just given an instruction by his boss or her boss to go to a site, collect the container of waste and take it to port. Likewise, we are unlikely to pursue the shipping line because they are in the business of export and moving goods around the world. In those circumstances, sometimes it's best for us to approach those as witnesses to give us statements and evidence about how the containers came to be loaded onto their ship, or transported from the point of loading and exported to the destination country. We also don't have to prove the mens rea, the mental element of the offence, because case law has said that the concern for the environment is so profound and the risk of environmental impact is so severe that it is the essence of the offence that we don't need to prove. So basically, that all we need to prove is that the waste was exported and it was exported in breach of the law, essentially. We don't have to prove that the person intended or meant to, it's just that they were involved in the export. The mens rea element then becomes important to us when we get to the sentencing stage, because that's where the court will determine the role of the offender and determine the level of penalty or the custodial sentence to impart on that offender. So in the UK, the maximal penalty is 2 years imprisonment or an unlimited fine. We can prosecute companies and we can prosecute directors of those companies, and we often do. We can also then pursue those companies and the directors for the proceeds of crime, the benefit that they have obtained from the export. So a simple example, in our waste electrical cases, the containers have been sold for about £7,000 for 600 or so items of televisions or fridges in that container. The container is part of a consignment of 10 containers, so that means a profit to the exporter of £70,000. We can pursue the exporter for that money. Next slide, please, Angelo. Right, so I've been given about 30 minutes, and so obviously I will try and whiz through these. I think you will be able to get a sort of drift by now that it's difficult to compress all of this into 30 minutes, but I certainly will try my best. So this is the law that we have relied on for the majority of our cases. Firstly, the European Waste Shipment Regulation, Article 36. That is the ban for the exports of certain types of waste for recovery to which the non-OECD decision does not apply. So the emerging economies, basically, or the developing countries is another way to put it. Countries such as China, India, and Indonesia, which are the subject of these two cases, they are non-OECD countries. In that list, Article 36, there are a number of categories of waste that are prohibited. One of them is hazardous waste, and the other is waste collected from households, which is the focus of this presentation today. The offence in our law is that a person commits an offence if, in breach of that article, he transports waste specified in that article, so waste collected from households, that is destined for recovery in a country to which the OECD decision does not apply. That is the law in our country. Next slide, please, Angelo. So we have to go back to Biffa 1, which is, there are two trials in this case over the past 5 years. And I thought I'd try and introduce a bit of humor because this is obviously a serious case. And if any of you have children out there, you may be able to recognize the toy in the middle of the photograph, the soft toy. That is Iggle Piggle from the program, The Magic Garden. I think it's The Magic Garden. In the Night Garden, apologies. And so we thought it quite ironic that in a bale of waste described as waste paper, there was poor Iggle Piggle sitting on the top of it as he was exported for being associated with this waste paper. Next slide, please, Angelo. So in the first case, there was 175 tons of what the defense called waste paper to China. They said that the material was properly sorted waste paper and that it could therefore go to China as a green list waste, as waste paper to be recycled. There was no dispute that the material was going to a mill in China. The dispute between us was whether the material was waste paper, as suggested by the defendant, or it was Y46, the Basel Code, waste collected from households, as claimed by us. And so our evidencing procedure in that first trial found soiled nappies, on average about 3 soiled nappies per bale, and you get about a ton of material in each bale. Clothing, tins, waste electrical items, wood and plastics. The kind of stuff that we are obliged to put out every Sunday evening to get collected for recycling by our local councils. And then that waste is collected and taken to a depot or a facility where it should be properly sorted into its single waste streams. And then it can be exported lawfully, provided that it is a single waste stream. There was a 3-week trial in 2019. The defendant was convicted by a jury. We have jury trials in the UK. And they were fined £350,000 as well as £9,900 for the proceeds of crime I referred to earlier. That was the amount they made, or we agreed that they'd made, from the sale of the 175 tons to the mills in China. They accepted in evidence that there was an average of about 3 nappies per bale. They also accepted that they had exported about 110,000 tons of material they described as waste paper to China in 2015. So simple arithmetic meant that in that period, they had exported 340,000 soiled nappies to China under the guise of waste paper for recycling. And that excluded the myriad other items of waste, such as the clothing, the tins, the waste electricals, woods and plastics. And on that basis, they were convicted. The jury found that they were in fact exporting waste collected from households that had not been properly sorted into the single stream waste paper they had suggested it was. There were two unsuccessful appeals, one on a point of law and one against the conviction. Angelo, next slide, please. Thank you. And so this was just another example of the types of items that were evident from the bales. That is a reflective coat that some of our services wear to make sure that if they are out at night, people spot them and they're not accidentally hit by cars or trucks or what have you. So that is a protective high-vis item that was quite obvious in a bale that they said was waste paper. How on earth did that get through their sorting process? Next slide, please, Angelo. So the point of law, I won't dwell on this much, but it was quite an important point because it was based on European law. And what the defendant alleged was that not only did we have to prove, because the onus is on us as the prosecutor to prove our case beyond a reasonable doubt, but not only did we have to prove that it was Y46, as we alleged, but we also had to disprove that it was waste paper as they alleged. The Court of Appeal on that point of law said, no, that's not the case. Those categories of waste are mutually exclusive. They have to be one or the other. The waste cannot be both. And so once we have proved Y46 to the criminal standard, then there is no need for us to disprove it as B3020. It is simply a matter for our jury system to either acquit or convict on the point that it is either Y46 or B3020. We don't have to disprove the latter. They then appealed their conviction, and the conviction centered on the evidence that we should have, or what was required to prove that the waste was in fact Y46. Because there is no standard in our law. There's no percentage or a threshold where something would magically change from Y46 to B3020, so 2%, and that is often knocked around by industry, or 1.5%, to say, well, at that point, the waste, provided it stays under that standard or threshold, can be waste paper, and if it goes over that, then it is something else. And our courts have said that no, because there is no standard in law, you cannot impart one. You can't say that there is one there. And so how does one determine whether the waste is Y46 or B3020? What does the jury have to consider? Well, the basic point is that for waste to stop being Y46 and for it to become waste paper, a green list, it must be properly sorted. And what that means is that the waste must be sorted so that any amount of contamination that remains after the sorting process is so small as to be minimal. A Latin equivalent would be de minimis. And so how does one then determine what is so small as to be minimal? And our Court of Appeal has said, first of all, you focus on the quantity of the contaminants, the quality of those contaminants, and the nature. If you get to the quantity stage and there is more than that de minimis amount, then you don't need to go any further. The case has been proved, because by that point, the waste wouldn't have been properly sorted. It would still be Y46 waste collected from households. Only if there is some concern for the jury about the quantity does one then look at the quality and the nature. So the food waste that we found, the soiled nappies, would that impact on the jury's job to determine whether the waste was Y46 or B3020? And what the court also said was that it doesn't matter what happens to the waste in the recipient country. So if a mill in India or Indonesia or China says, well, you can send us 10% contaminants because we'll deal with it, our law says that is not the test. Because of the fact that the waste starts at the point of loading, that is where the categorization is relevant. So whether it is Y46 or B3020 is relevant at the point of loading for export. That factory or the waste site in Manchester or Liverpool or Oxford or Cambridge, that is the point of loading. And that is the point where the categorization must be determined. And so any standards that are raised in the recipient country, those are irrelevant for our jury's purpose to determine whether the waste, when it left the site, was either Y46 or properly sorted so that could become greenless waste B3020. Next slide, please, Angelo. So I think I've been going for about 15 minutes. So on that basis, and bearing in mind, I spoke about the 110,000 tons that they exported, and we found an average of about 3 nappies per bale in those containers. The second case happened shortly after the appeal against conviction, and the containers were stopped on the way to India and Indonesia. And I should say that at the moment, we focus only on containers that have been stopped by us. Some of the containers got through, and the fact that they got through, that didn't change the jury's task of what they had to determine. Because that goes back to the point, well, it doesn't matter what the facilities in the destination countries can do with it. It matters what the waste was when it left our shores. Again, the defense had the same approach. It was properly sorted waste paper, and our position was exactly the same. So it was a bit like Groundhog Day, really, that we were saying, well, no, this is Y46. Your facilities, your method of sorting hasn't changed since the last case. And so we had a further 3-week trial just gone, which finished in July, and they were convicted again of exactly the same offence, but this time to India and Indonesia. And another important point from our Court of Appeal was that the ban is on the export to a non-OECD country. It doesn't matter that it is Indonesia or Brazil or China or India or any other non-OECD country, because the ban is to non-OECD countries. It is a blanket ban. So the individual countries, for the extent of proving the offence, isn't particularly relevant, provided you can establish that they are in fact non-OECD countries. And so on this occasion, the court fined them £1.5 million. And that was essentially because of what we said was their reckless attitude to the offending in the case. They had simply not taken on board what had been said previously, and they carried on regardless. And on this occasion, there was a proceeds of crime of £38,000 for the 1,050 tons of waste that was exported. Next slide, please, Angela. So I thought I'd show you just a few photographs of our evidencing procedure. And there you can see our officers in a container and sifting through what looks like a bale of waste paper. And in the front, you can see a blue bucket, and probably in the background as well, there's a second blue bucket. And what the officers are doing there is extracting the waste contaminants from the bale on the outside, and then it is broken by a pair of shears and then taken apart. Now, those bales are so compact, and there are so many bales in a container, about 25, that we just do not have the resources to break open each bale in each container, because the process of doing one takes about an hour and a half. And so we do about 3 bales for a container, because that, we say, is a representative amount of the bales in the container. That process itself takes a full day. So if there is a consignment of 10 containers, you could have officers there going through this waste for about 10 days. And that is just not an efficient use of our resources, because of having limited resources as a government organization. Next slide, please, Angelo. So having taken the waste out from the bale, broken it, and put it into those buckets, this is the waste that has been spread over an area inside an evidencing building. And again, this was just a representative sample because the bale was so compact that they couldn't get all of the contaminants out of a single bale. Next slide, please, Angelo. And this is just a close-up. And so you can see if starting on the left, again, remember this was described as waste paper. The tins on the left, and then in the middle, the soiled nappies, and then on the right, clothing, and at the top of the photograph, all sorts of amounts of non-paper items. There's a cat food pouch, there's drink bottles, there's a chocolate milk tin, and all sorts. And again, what was described as waste paper by the exporter. Next slide, please, Angelo. And this is just a representative of the kind of material that the soiled nappies and sanitary pads and medical items that were found. This is a bale in which we found 7 soiled nappies and then the medical item as well. Some of them had 2 nappies, others had 8. The average was about 3. Next slide, please, Angelo. And so going back to what was said in the Court of Appeal as well, how is a jury to decide whether the waste is Y46, as we allege, waste collected from household, or waste paper as alleged by the defendants, given that there is no standard? So again, it was accepted in evidence that there's a bale weight of about 1 ton per bale. It was accepted in evidence that there were about 3 nappies per bale. It was also accepted in evidence that those tins that we saw in the photograph, there were about 50 tins per bale on average. Angelo, could you just scroll down to the next screen, please? Thank you. About 40 plastic bags per bale and about 25 items of clothing per bale. And so it became almost an exercise in mathematics again, arithmetic. So we, for argument's sake, said, fine, let's accept that it's 1,000 tons as opposed to 1,050, just for calculation purposes. By doing that, it was accepted in evidence by the defendants that on this occasion, there were 3,000 nappies in the order of 1,000 tons, 50,000 tins, 40,000 plastic bags, and 25,000 items of clothing. They accepted again that they'd exported about 100,000 tons of this material described as waste paper. So simple arithmetic then gets round to the fact that of the 100,000 tons they'd exported that year to India and Indonesia, there were 300,000 nappies, 5 million tins, 4 million plastic bags, 2.5 million items of clothing. And that excludes all the other types of waste that was seen in the waste. These were just items that we focused on, just to give some form of signpost to the jury when looking at the waste. Now, again, as mentioned, people raise percentages and say, well, there must be some form of cutoff, but there isn't. And what the defense said, well, this was 99% pure waste paper. They didn't provide any evidence to that, but that was what they alleged it was, meaning that it was about 1% contaminants. So even for argument's sake, if you take it that it was 1%, you can see that that 1% would allow 3,000 nappies, 50,000 tins, 40,000 plastic bags, and 25,000 items of clothing in an order or a consignment of 1,000 tons. And that is the issue with percentages, is that it skewers the contaminants, and it is difficult to establish. And if one was to say, fine, accept 2%, then you just double those figures. And so of the 100,000 tons, the 5 million tins becomes 10 million tins for a 2% acceptable threshold. And that is where we say It is for the jury to decide on a case-by-case basis, looking at the contaminants in the bales as to whether it is Y46 or not a percentage, not a particular threshold. If there was one there in law, then of course our task would be different, but there isn't. Okay, Angelo, thank you. And so this was just, I've just cut and pasted 2 paragraphs from the judge's sentencing remarks, and they go like this. The 1989 convention, that is the Basel Convention, raised the signatories' concerns and recorded that they should take all necessary steps to control the transboundary movement of waste. The policy reasons behind this is that to allow household waste to be exported would be to transfer to a third country, and we don't want that as the UK. We do not want our environmental problems sent across to the other end of the world for somebody else to deal with. The environmental health and safety hazards inherent in the receipt and processing of undifferentiated waste. This being so, even if the foreign state could safely and environmentally recover the recycled parts of the whole, which is what our Court of Appeal said, a risk, of course, in any such cross-border sale is that the consignment may be resold after it leaves the UK, and there is no control over what then happens to it. And then finally, towards the end of the sentencing, the judge said the following: standing back and looking at this sensibly, can it really be said that Biffa were incapable of recognizing that if they are still seeing 3 nappies or 50 cans per ton, that this was not a problem? That means on these 2 contracts, 3,000 nappies and 50,000 cans, it was readily foreseeable that a jury would find that unacceptable. If they did not know before this case these figures, it rather begs whether they learned anything from the previous case. And so one can see how the court viewed the defendant's approach to this. And like I said, that the intention or the approach taken by the defendant, although not relevant to prove the offence here, is relevant for the purposes of sentencing. And so for the first offence, they were fined £350,000. For the repeat offence, they were fined £1.5 million. And that is a record for a waste export offence in the UK. That is the sum total of my presentation. I think I've been about 30 minutes. I hope I'm about right on time. I'm hoping that was useful. I'm hoping that there may be some questions. And I'd just like to say thank you again for the opportunity to speak to you today, to Amanda and to Matthew, and to Angelo for helping with the slides, for driving the bus on this occasion. And I hope there is opportunity in future to meet, but that time that we can all meet in person. So thank you very much.
Well, thank you so much for your presentation, and you were completely fine with time. I was going to leave you even more time if you needed, because it's absolutely fascinating to hear and the intricacies and the details of the case. So now we are going to open for Q&A. So please, anyone, if you have questions you want to share, and also maybe comments from your experience, you're absolutely welcome to do so. So you can use the chat to write down your question, or you can also raise your hand. So using the little reaction button, you can raise your hand, and we'd be happy to give you the floor if you want to turn on your video and ask your question. So I've already received a first question from Christopher Schellel. Yes, if Christopher, you want to start, great.
Hello, Amanda, can you hear me?
Yes.
Wonderful. I should say I'm a member of the press just before I get started. My question is, the UK exports a fair amount of soft plastic waste to be processed abroad. As I'm sure you'll know, Howard, that type of waste, in order to be effectively recycled, needs to be pretty well separated into different types of soft plastic for it to be processed effectively. What are the obligations in terms of sorting that waste at the point of loading, or is soft plastic just one distinct category that can be shipped?
Christopher, thank you. it may be something that can be dealt with outside of this webinar. The basic point is that for any green list waste to be exported, it must be properly sorted. That is the bottom line in UK export law. And so for it to qualify, the plastics to qualify as green list, it must be properly sorted.
Okay, thank you.
Thank you. So do we have more question? I don't see more question in the chat. I'll be glad to. Okay, we have one more question. I don't see the
Amanda, we have two. Amanda, we also have two people, Union and Dia, with their hands up. So.
Okay, somehow I'm not seeing those hands up. I'm sorry for that. Okay, now it's working. Please go for it. Yes, it's you, Yuyun, if I pronounce correctly. And yeah,
yes.
Thank you.
Okay, thank you, Amanda. My question to Howard is that, okay, before that, thank you so much, Howard, for sharing the details of the case. I followed your case and we talked a couple of times. I'm sorry, I'm in a restaurant. I have a question about the company who facilitate Biffa to do this, which is Ekman Recycling. So who is the main the naughty part here? Is it only Biffa or also Ekman Recycling? And have you notified the Indonesian government about this and how in the future we can prevent this from happening? Thank you.
Yuyun, it's nice to see you again. I hope you're having a nice meal in the restaurant, wherever you may be.
Thank you. I'm in Edinburgh.
Oh, in Edinburgh. Oh, okay. So I'm assuming you on your way back from COP26. So.
Yes, indeed.
Well, I suppose it is always, as the prosecuting authority, it is always for us to determine who to prosecute. That is the discretion that we have. And when we prosecuted Biffa the first time, we pursued just Biffa. And the second time we pursued just Biffa as well. But that is, and of course, yes, the brokers were part of the process of facilitating the export. And as stated, anybody involved in the export can be caught by the regulations. But it is a matter for us to decide who we take enforcement action against. And we decided on both occasions to pursue the company, the sites of loading, where the waste was exported from.
What about the notification to the Indonesian government and how to prevent this from the future, for happening in the future?
Well, I mean, that's a tough question, I suppose. Notification to the Indonesians, that may be something that is probably above my pay grade, I think. That is something that could be followed up outside of this webinar. To do it again, or how do we stop that from doing again? Well, it's prevention and detection. It's what the Environment Agency does as the regulator. Hopefully that the result has been circulated. I know that it's appeared in the press here quite a bit, and so the message hopefully is getting across, is that for people to export waste, it must be properly sorted. Otherwise, if it is stopped by us, we will look at it on a case-by-case basis and then take a decision on what kind of enforcement action we might take. It's difficult for us to say how we can stop it in the future, because there is a lawful trade in the export of waste. It's making sure that the waste is traded lawfully, and where it's not traded lawfully, that we look at the enforcement options available to us under our law.
Okay, thank you, Howard.
Thank
Amanda.
you. And
hello.
Yeah, we're getting a few questions coming in. So let me just, I'm just going to put them together for Howard to look at those questions. So one specifically about the case, and I think we have to remember exactly, like, let's start from talking about this particular case. That's very informative for also bigger question. So one question from Kitty D. So how did the case start? Did the China, Indonesia, India complain and send back the containers to the UK? And in the case that similar bales were shipped to my country from the UK, what's the best approach to take and who to contact? So very concrete question. And then we have broader questions. So from Malaysia, sending back containers of plastic waste to the UK. What happened to those containers and the waste? If the shippers and exporters are being identified and charged. So maybe you have a vision a bit of what's happening, especially with the containers from Malaysia. And other question, I see Shivani, a broader question asking why do we allow export of any type of waste at all? But so Howard mentions a ban concept, so maybe to come back a bit on that. And Hubert asking about UK law and what it says on export of obsolete electronic cooling appliances to Ghana. And I know, Howard, you've been also handling cases with Africa, so maybe that could be something of interest. Okay, so that's already a few questions, and then we take another batch of questions.
Wow, okay. Where do I start? Well, in terms of this case, the containers were mainly intercepted at port by our officers. And so we have had other instances where the waste has been returned, repatriated under law from recipient countries. And on those occasions, we have taken enforcement action. Once those containers have been repatriated back to the UK. In terms of the Malaysian containers, again, that's something I probably can't answer in this webinar. It's, again, case by case basis. I would need to make inquiries as to where those containers are. So I wouldn't want to bind myself or the Environment Agency or commit us to anything on any other containers. Because yeah, this may sound like a politician's answer, but today we are talking about just the case that I've presented on and what we did in those circumstances. The Malaysian containers, again, that may be something that if you drop me a line, I might be able to forward it on to the right people to then get back to you. That's probably the best guesstimate I can give on those containers at the moment. And then with Ghana, yes, we've prosecuted for exports of hazardous waste to Ghana. That was a case where the defendant received a 16-month custodial sentence. He'd exported electrical items, including old-style CRTVs and refrigerators containing R12 substances to 4 African countries, including Ghana. And so the law is there. It is the same law. As I said, the offences for exporting waste to non-OECD countries. And Ghana is a non-OECD country. And if the ban applies to the waste exported to Ghana, then of course, we would look at the exports and then decide on what kind of enforcement action we might take in those cases.
Okay, great. So then we have a question from DA, if I pronounce correctly, sorry if I'm not. So what is the criteria of the company that can export the waste lawfully? So for the waste generator, if the waste generator is based in the UK, so if you can just go through the how do we export lawfully, yes, and broader question, how can we have uniform criminal law for violation of environmental laws? broad question again. So yeah, if you can try to respond to those forward.
Okay, so in terms of lawful exports, we were, as everybody probably knows, a member of the European Union. We left a year ago. We retained a lot of European environmental law, and so we still apply that European environmental law as at the time we left the EU. And that law, the European Waste Shipment Regulation, brings in requirements from the Basel Convention and the OECD decision on the exports of greenless waste. Essentially, and this is a very, very summary response, we operate a traffic light system for the export of waste. And so basically you have greenless waste, and provided that greenless waste is properly sorted and it classifies as greenless waste at the point of loading, then that waste can be exported to most countries. There is a regulation in the EU that allows all non-OECD countries to provide responses to the EU as to the controls that are required for certain types of waste. And so a greenless waste, such as waste paper, might be allowed by a country such as India, for example, but it might be banned by another non-OECD country. And so whilst the greenless waste could be exported, it is also important to know whether that could be exported under other controls, and that is called notification controls, which is the amber list, or in the traffic light system. And with that, then the waste needs to be exported, but before it gets exported, both the country of dispatch, which is in our case, England, and the country of receipt must agree and consent to that export, and that is set out in the Basel Convention. And then finally, there is the red list, which is the ban, which is the Basel ban, which in UK law, European law, Article 36, the ban on the export of hazardous waste and other types of waste to developing countries. So that's a very, very quick run through what is a very complicated area of law, and we could probably speak for days about it. And then uniform criminal, how do we uniform or make it in sort of one family approach to criminal law? That is the million-dollar question, I suppose, is how can we, as prosecutors, as governments, agree on a uniform approach to environmental law? I'm afraid I can't really answer that, and that's why I suppose our delegates have been thrashing out agreements at COP26 for the past 2 weeks. It may be that eternal question, and all we can do is strive to get to that eternal question, and with cases such as these, demonstrate that we do not want our unlawful waste exported to recipient countries because they have issues of their own in emerging economies.
Exactly. So another question from Muli Venkatesan. Maybe you want to, yeah, please go for it.
Thank you, Amanda and Barrister Howard. My question is to the barrister. In the beginning of your presentation, you mentioned that you don't need to prove, but you just have to show that somebody is involved. Could you please explain more on that? And I have one more question. Maybe after this, I will ask.
Yeah, sure. Thanks for the question, Millie. So what I was trying to explain, and perhaps I didn't explain properly, was in terms of the intention of the person involved. We don't need to prove, because of the public health and environmental concerns around the export of waste, we don't need to prove that they intended or what their thoughts were around the exports of the waste. All we need to prove is that the items were waste at the point of loading, that the waste was destined for recovery, recycling operations, and destined for operations in a non-OECD country. So those are the elements of the offence that we as the prosecuting authority have to prove. The onus is on us, The defendant can stay silent. They don't have to say anything. It is our onus, our duty as the prosecutor to prove those elements of the offence. It's only when we get to the sentencing stage, once and if the defendant has been convicted, that their intentions or their involvement can be considered for the purpose of sentencing. And so if somebody deliberately exported waste, then they are likely to get a more significant penalty than if there was some negligence involved, where there may have been negligence of the law, they didn't know what was being exported when they should have known, or their company procedures weren't of the standard expected of those types of companies, and they've now put measures in place to improve their procedures so that those types of offending don't reoccur, then the penalty may be less than somebody who's actually deliberately gone about exporting waste. And so, for example, in the export cases to Ghana and West Africa, we had instances where televisions were packed in the front and they looked like they were being packed safely. But when you took the first two rows away from the container and you looked into the back of the container, it was just packed together higgledy-piggledy. There was absolutely no protection of those electrical items for their 4-week voyage from England to West Africa. And what we could say there was that there was some form of deliberate act or intention behind the exporters to perhaps con or trick the buyers at the site in West Africa, and also the customs officers and police officers inspecting that what was in the containers was in fact a lawful product, when in fact on second look, once you go into the depth of the containers, it was in fact what we said was waste.
Thank you. I really appreciate it. My second question is, you shared us the Biffa case study. My question is, since it is already in public, can I see the documents or evidences that is used in this case? Very specifically, bill of lading or Annex 7. Was there any other intermediary brokers or contractors involved in this? And on the extension, how do you transform what you have found to the brand owners? Anywhere in the world, no country has a capacity to recycle the plastic waste generated in their country. This is known and proven. How are you transferring this knowledge and the crimes happening because of you choose to buy a cheese package in a supermarket with a plastic packaging, creating this crime? How are you communicating this to the brand owners? Thank you.
Okay, a number of questions there, Millie. So firstly, in terms of the documents that we used, it's probably better you contact me directly via email and we can discuss that, because there are requirements here that I need to consider before any decision to disclose any documents can be given to you. So that's something that I think we should probably try and discuss away from this seminar. Secondly, in terms of what I could summarize as producer responsibility, the manufacturers of plastic bottles, crisp packets, electrical items, batteries in Europe, and we've obviously retained this law now, they are obliged to fund the equivalent amount of waste that is produced as to what they put on the market each year. Again, I'm summarizing quite succinctly. So, for example, if Coca-Cola, I don't want to drop names in, but if a major bottle producer makes 100 tons of plastic bottles a year, they are obliged to fund the similar amount of recycling of bottles, and they do that by joining recycling schemes, who then take on their obligations and contract with recyclers to then recycle that waste. It's not a perfect system, because we know that there are people out there who will always seek to get around the law to make money. It's probably what keeps a lot of us employed, is making sure that people do things properly.
Yep, thank you, I appreciate it.
Thank you. I see other question and maybe comments. First, Dia, maybe you want to also share your video and make your comments from Indonesia.
Yeah, I'm sorry. I think my connection is not very good, but I hope you can hear my voice. Yeah,
Yes.
so unfortunately, Indonesia is allowing the import of certain non-hazardous waste for industrial purpose, as long as it does not contain contaminants. So basically, some waste under the Basel Annex 9. And this type of waste does not need PIC, prior informed consent, based on Basel. So sometimes both of the importing and exporting companies skip the notification part. And so in order to strengthen the procedure in Indonesia, would it be possible for Indonesian government to require the exporter to get approval for the UK Environmental Agency or surveyor to make sure that the waste containers fulfill the requirement? Thank you.
Thank you, dear. Again, I think that's probably more a question that needs to be put to the Indonesian authorities. It's not really something that I could provide an answer to here, because as I have said, the law here is that the waste has to be properly sorted to qualify for an export to a country that will allow it. And what our courts have said is that the fact that a recipient country has mills that says, well, we can take a certain percentage of contaminants is irrelevant to our jury's task, because they need to decide what the waste was classified as when it left its point of loading in England. And so I think I don't want to sound like I'm trying to avoid answering your question, because I think it's probably better placed to put that kind of question to the Indonesian authorities.
Thank you, Howard.
Thank you. And so next we have a question from Matthew, please, and more concretely about the evidence and the case.
Thank you, Amanda. And in some ways, I following up that question from Dia in Indonesia, there's also this question of evidence. Again, the Biffa prosecution was very important because it did go to the Court of Appeal or Court of Criminal Appeal for discussion about certain requirements that needed to be proved. But I was curious about the photographs, and you mentioned that if you had to go through all of the waste, it might take the whole team 10 days to sort of summarize or sample the waste. So I was really interested in terms of that proving from an evidentiary perspective the content or the level of contamination in the waste itself. Is that, do you take it as a container load and then do a particular sample? And is this something that can then be challenged by the defendant in terms of photographs or sampling or expert evidence? I mean, how does one prove that the waste itself is either contaminant, or if it's mixed, that the mixing exceeds the requisite percentage to then become a breach of the law? Okay,
Matthew, now that I'm aware that this is live streaming, I probably have to be a little bit marked about what I can and cannot say because of how we do things in the UK, and so what I can talk about is the general processes of what we do, and that is to make sure that when we do carry out our evidencing, that the people who are exported are involved in the export are given an opportunity to attend. They are then invited to attend and observe the evidencing procedure. And we collect the evidence as it was in this case, that was described as waste paper on the export documents. and we broke a representative amount of bails that the defendant was content with. In fact, the defendant chose those bails. That was in evidence. It was an open court, so I can say that much. And those bails were then broken up and selected for evidencing, and the contaminants taken out, the contaminants retained, and some of the contaminants were produced in open court. It then emerged in evidence as to what was in those bails that we'd evidenced, and in terms of what the Court of Appeal said, quantity, quality, and nature, it came out in the evidence from the bails that we had evidenced and from the other documents we had for the consignment, the conclusions that I summarized, that it was accepted in evidence that there was at least 3,000 nappies in the order of 1,000 tons. There was at least 50,000 tins, and there was about 25,000 items of clothing and 40,000 plastic bags. And so when that evidence was given in open court in front of the jury, that was part of their overall assessment that they had to make, and they were directed by the trial judge to consider the evidence as they heard it as a whole. There was also expert evidence that was called by the defendants about the nature of processing of a mill in general, of what a mill can and cannot do, and they were then directed by the judge to consider the evidence as a whole, having heard our story, our version of events, and the defendant's version of events that was given during the trial. And on that basis, and this is where the Court of Appeal has said, is that each case must be decided on its own facts on a case-by-case basis. The jury on both occasions convicted the defendant company of exporting Y46.
Well, thank you. And if I may jump, I would also have a few questions to add. One is more of a comment. So I know that the EU regulation on shipment of waste from 2006 is actually being reviewed. The new regulation should be adopted in a few days, 19 November. And it's to make this regulation even stronger in terms of controlling and banning as much as possible export of waste. Yeah, as you mentioned with Brexit, so the connection with EU law is also evolving. But do you know what's going to be like for UK law? Are the standards going to stay aligned to so the current regulation 2006, or there's a process that's going to start in the UK? So just wondering how this is looking like for the future. Another, I guess, something that's quite striking when we hear your explanation of the case and Biffa 1, Biffa 2, and somehow we're also wondering, is it going to be a Biffa 3? In the situation of repeat offenders. And I understand that in the second judgment, there's a clear message to say there was reckless behavior and the lesson was not learned from the first case. And we get a second judgment with a much stronger sanction too. So 1.5 million pound, which would be 2 million USD. US dollars. Is that enough to stop companies to be in the reckless behavior, or also to kind of extrapolate and think a bit about sanction, and how do we make those sanctions effective to stop the problematic and criminal behaviors? So yeah, that's from me.
Okay, right. So 3 questions, the way I understand it, Amanda. So the first question, yes, the European Waste Shipment Regulation is being reviewed by Europe. We are no longer part of Europe, so that is a matter that I'm not in a position to comment on. It's safe to say that I'm aware that it is being reviewed. Again, way above my pay grade, but my understanding is that part of the Brexit agreement was that we have brought in the European law as it existed at the time of Brexit midnight on the 1st of January, and that is what we are currently applying. It is then a matter for us now as a sovereign state to decide on where we go. Again, I'm not binding the UK government here because clearly I can't comment on those kind of issues. But yes, the waste treatment regulation is being reviewed at the European level, and no doubt we will probably hear about those reviews through our Impel network and through NP. And again, well, again, I can't really comment on how that might happen because I don't know the outcome of the review yet. In terms of well, yes, the case was a follow-on. There were 2 prosecutions of this company. I don't, as the regulator and the prosecutor, we just don't know who or when the next case will fall on our desk. And so to say, is there a Biffa 3? I can't speak for the company, and I'm not in a position to. But they did say that they are no longer exporting to non-OECD countries, and that is a statement they've made, and that is where they are. Again, I can't comment for them, and I can't bind the Environment Agency to say what we'll do in future against anybody who breaks export law. And in terms of sentencing, we have a sentencing guideline that Matthew is well aware of. Amanda, you may have seen it, and that is applied in the UK for environmental offences, and it is based on a stepped approach. And when it comes to companies, it is based on their turnover. And so a court has a guideline document to assess an offender on a case-by-case basis, applying those sentencing guidelines. And the purpose of those guidelines is to make sure that the sentences are uniform based on the facts of each case. And so that where a court in London is sentencing a company that has a turnover of 100 million, hands out an equivalent or similar sentence to a court in Liverpool or Manchester that might be sentencing £100 million turnover for a similar offence, so that there is parity between the two. There's a basis on which the judge, the sentencing court, can then pass the appropriate sentence in each case. One of the goals or the aims of the sentencing guidelines is to make sure that there is an impact on the company, that the shareholders sit up and take notice, so that it doesn't just become a cost of doing business, that it is cheaper to offend than pay the penalty than it is to offend. And the idea behind the guidelines is to make sure that that companies do take into account the risk that their actions have on the environment, and to make sure that they have measures in place to make sure it doesn't happen again.
Yeah, thank you. And Matthew shared in the chat sentencing guideline. I think that can be also useful to look at for many countries in Asia. So there's another question from Dia about UK law, and if there is a UK law specific regarding the procedure for waste repatriation. And I guess we heard a lot of the take back and the containers being sent. So there's a lot of interest on this dimension of the process.
Yes, well, the take back obligations are set out in the same regulation, the waste shipment regulation. And the starting point is that if the illegal export is the responsibility of the notifier of that export, or the person who arranged the export, then it falls upon them to be responsible for the costs of repatriation. If that person is declared bankrupt, then there are other members in the chain or players in the chain that can be pursued as a replacement for that person or the company that has become bankrupt. But the first step is to look towards the person responsible to ensure that the costs of repatriation are met by that company or that person. What the law then says is that if all else fails, then the costs are borne by the competent authority, the regulator, which would be the Environment Agency, for any illegal repatriations of illegal waste back to England. If the illegal waste is the responsibility of the consignee, the person in the recipient country, then it is their responsibility to deal with the costs of that illegal shipment. That is set out in our waste shipment regulation, and again is mirrored in the Basel Convention too.
Exactly. So we still have a few more minutes for the Q&A. So I don't know if there are more hands being raised and that somehow my screen doesn't want to show me, or if there are more questions, please don't hesitate. And Matthew, if you have more questions, I'm sure you must have more questions because you've also experienced prosecuting waste cases. So, so otherwise, I don't see more comments. But I guess we've already covered quite a few different aspects of the case and how, of course, it brings to mind so many bigger questions. And thank you so much, Howard, for sharing with us. That was absolutely fascinating. And please, Howard, if you have a few last words, comments, something you want to highlight from this case or your experience with illegal waste export, something you want to share, last message, please.
Well, just again to say thank you for the opportunity to speak to everybody today, and I hope that it has been informative. And of course, I'm not the encyclopedia for waste exports. I try and do what I can. We prosecute cases where the decision is to prosecute, and the aim and the goal is to make sure that our waste doesn't end up in countries that doesn't want it, and where it impacts or risks impacting on those countries when those emerging economies have issues themselves to deal with. And of course, there is legislation there that allows the lawful export of waste, and we want to make sure that where waste is exported lawfully, it is done so properly. So thank you very much, and again, thank you, Matthew, and thank you, Amanda, and Angelo, thank you for driving the PowerPoint presentation, and I look forward to hearing or seeing some of you in future.
Well, thank you so much. And yeah, very important last words on how do we share those concerns on environment and health across the continent, and something very important for UN Environment Program to help cooperation between source and destination countries and regions. And the last word would be for Matthew, who's going to introduce the next webinar of the series. Matthew.
Thank you. Thank you very much indeed. And again, on behalf of the Asian Development Bank, UN Environment Program, the Asian Environmental Compliance Enforcement Network, and the Asian Research Institute for Environmental Law. Thank you very much, Howard and Amanda, for the presentations today and last month. And Howard in particular, thank you very much for sharing the experience as an advocate and someone who actually, as a prosecutor, brings these to court. And I think, you know, one of those things that we didn't explore, but hopefully over the next, you know, months, when we look at the role of environmental crime, we can explore those professional obligations of prosecutors and the way that the systems work together to ensure that the investigation can occur appropriately, the prosecution occurs in accordance with all of the obligations as required, and also the judges are well trained and understood. Most of the cases here on waste would be done by a judge alone, so the judge would be the determiner of fact as well as the law. In Australia, my experience over many years with environmental crime is for judge alone trials, either in the local court or in the Land and Environment Court, where judges with specialised environmental law knowledge nevertheless have to also make determinations of fact as well as law. And that, of course, raises a whole range of issues, in particular about the rights of defendants, both as individuals and the issue of prosecuting companies or legal entities. So, Howard, the important thing about the Biffa prosecution is that it was an exceptionally large fine that gathered a lot of interest, but also highlighted one of the important things about environmental crime, which is the denunciation of the actions of individuals and corporations. Crime is something that we say must not pay, and is something that governments acknowledge is detrimental to society. We know, and we heard last month from Amanda and Nancy, that environmental crime is something that eats at the very heart of society. It causes massive amounts of damage. We thought they were victimless crimes, and we now realize that we are all the victims for environmental crime. And this is a lead up to our next webinar, which will be on Thursday, the 9th of December, and it will be the last in the series of Environmental Law Champions webinars organized by the Asian Development Bank and our partners. And it's a very exciting webinar that looks at the new idea for an international crime of ecocide to join the crimes against humanity, the crimes of war crimes and genocide as one of the top sort of criminal offences for individuals who cause wanton or negligent harm to the environment. And so it's going to be a very interesting webinar. It's the first time this sort of discussion has occurred in Southeast Asia, from the launch of the new definition from the Ecocide Committee in June this year. We're going to be joined by Christina Voigt, who is the current new chair of the World Commission on Environmental Law, Rizwana Hassan, who is the chief executive of the Bangladesh Environmental Law Association, was on the working group, one of the foremost environmental lawyers in South Asia. And we're also going to be joined by an Australian environmental lawyer, Emma Carmody, who is a solicitor with the Environmental Defenders Office in Australia, and is also an expert on water law. She also represents the Ramsar committee as a legal advisor. So it's going to be a great panel on the 9th of December. We'll be sending you all details. We look forward to welcoming you there for our last webinar of this year, looking at the crime or the potential crime for ecocide. So on behalf of all our supporters, thank you, Howard. Thank you, Amanda. Thank you very much, Angelo and Gladys, for the technological support. And more importantly, thank you to all our participants who have registered and attending tonight. So goodbye. And in the midst of COP26, when all attention is focused on climate, we've looked at another little bit of environmental issues such as waste. So thank you again, Howard and Amanda and everyone for being here today.